Good morning, this is the Kelso Report for Tuesday, December 4th, and I'm your host, Clark Kelso. Our first case today involves the qualified immunity of a police officer. Then we have a death penalty decision from the California Supreme Court, an automobile search and seizure case, and a habeas decision involving expert testimony that turned out to be not so expert. We begin with the Ninth Circuit. Police officers are entitled to qualified immunity from damage claims under Section 1983 unless the plaintiff can show that the officer violated a constitutional right, and that right was clearly established at the time of the occurrence. The individual circumstances of the case do not provide a basis for qualified immunity if the unlawfulness was apparent in light of pre-existing law. So the question is whether the state of the law at the time of the occurrence put the officer on fair warning that his conduct was unconstitutional. In Sims v. Stanton, the Ninth Circuit faced a situation where an officer injured a property owner when the officer, who was chasing a possible misdemeanant, kicked down the entry gate to the owner's front yard. The owner happened to be standing behind the gate at the time and was seriously injured when the officer kicked it open. Now, the Fourth Amendment prohibits officers from entering an enclosed front yard without a warrant to the same extent that it prohibits them from entering a home. There's prior Ninth Circuit precedent on that point. Since the plaintiff's front yard was enclosed, the issue in this case was whether some exception to the warrant requirement, such as an emergency or exigent circumstances, existed. Well, there was no evidence connecting the suspect to any felony crime. And the only misdemeanor here was refusing to stop at an officer's request or command. Instead of stopping, the suspect ran through the plaintiff's yard. According to the Ninth Circuit, a reasonable officer would have known in 2007, when this incident occurred, that a warrant was required to enter the enclosed front yard, and that kicking down the front gate constituted an unconstitutional entry and search. Accordingly, the officer was not entitled to qualified immunity. Next, we have a death penalty case from the California Supreme Court and another affirmance, this time by a 6-1 vote. In People v. Hommick, the defendant was convicted by a jury of 1 count of conspiracy to commit murder and 2 counts of first-degree murder, as to which the jury found true financial gain, multiple murder, and lying in wait special circumstances. Following the penalty phase, the jury returned death verdicts. It took the Supreme Court 116 pages to reject all of the defendant's claims. The most interesting argument, and the basis for Justice Kennard's solo dissent, was that the defendant had been previously convicted in federal court for murder for hire based on the same murders. Well, that raises a double jeopardy question. For the majority, there was no double jeopardy problem under the federal Constitution under the dual sovereignty doctrine, and no problem under our slightly broader statutory double jeopardy provision, because the federal prosecutions did not encompass the lying in wait allegations. So the state prosecution was for a different offense. Now we have another search and seizure case, this one from the California Supreme Court. The law of search and seizure in the context of automobiles is wonderfully complex, and when that law intersects with the law related to searches of a parolee, you can be sure to get some interesting results. That's what the California Supreme Court faced in People v. Schmitz, and the case produced a 4-3 split, with the majority approving the search. The facts were essentially as follows. An officer, aware that the front seat passenger was a parolee, searched the back seat of the defendant's car and recovered drugs and drug paraphernalia from a chips bag and a pair of shoes. Defendant, the driver, sought to suppress the evidence. The majority concluded that the search was reasonable under the Fourth Amendment, which permits a search of those areas of the passenger compartment where the officer reasonably expects that the parolee could have stowed personal belongings or discarded items when aware of police activity, because the parolee doesn't have full Fourth Amendment rights. Additionally, the officer may search personal property located in those areas if the officer reasonably believes the parolee owns those items or has the ability to exert control over them. So the lesson here is, if you bring a parolee with you as a passenger, you can pretty well expect the entire inside of the car to be fair game for a search. Finally, an interesting habeas case. The outcome of many trials is heavily influenced, of course, by expert testimony. But suppose the expert got it wrong. In particular, in a criminal context, what happens when the scientific basis for an expert's testimony is substantially undercut after the conviction? Does that establish a basis for habeas relief? That was the issue before the Supreme Court of California and in Ray Richards. And in a close 4-3 decision, the court held that this type of a problem does create a basis for habeas relief. But it doesn't get you a ticket out of jail. Well, here are the facts. At Petitioner's 1997 trial for the murder of his wife, the evidence against him was circumstantial. One of many pieces of evidence linking the petitioner to the crime was a post-mortem photograph of the victim's hand depicting an indistinct crescent-shaped lesion. The prosecution's dental expert stated his opinion that the lesion was a human bite mark, and after comparing the bite mark to the distinctive arrangement of petitioner's lower teeth, the dental expert stated that the petitioner's unusual dentition was consistent with the shape of the mark depicted in the photograph, and that he could not exclude petitioner's teeth as a possible source of the mark. According to the expert, petitioner's unusual dentition occurred in only 2% or less of the general population. The jury found petitioner guilty as charged. In 2007, petitioner sought habeas corpus relief in the San Bernardino County Superior Court, claiming that new evidence established his innocence and that his murder conviction was based on false evidence given at trial by the dental expert. In a declaration supporting the petition, that same expert stated that his trial testimony regarding the statistical frequency of petitioner's dentition was not based on scientific data. Moreover, after examining photographs depicting other lesions on the victim's body, the dental expert said he was no longer certain that the lesion on the victim's hand was a bite mark. Supporting declarations by other dental experts agreed, based on newly available computer technology, that the prosecution's expert had testified inaccurately at trial. Well, the majority phrased the issue as follows: whether a conviction is based on, quote, false evidence, close quote, when it depends in part on the opinion of an expert witness and post-trial advances in technology have raised doubts about the expert's trial testimony without conclusively proving that testimony to be untrue. Doubts, but not conclusively untrue. The majority concluded that in such circumstances, the expert's trial testimony has not been shown to be false evidence. It has been shown to be possibly false evidence, but that is not enough for habeas relief. Instead, according to the majority, the information garnered from the technological advances may be presented as newly discovered evidence in support of habeas relief. But that relief should be granted only if the new evidence points unerringly to innocence or reduced culpability. On the record in this case, the court held the petitioner had not satisfied that high showing. And that's it for today's Kelso Report. Have a great day in the law.